Today, again, we shall look at intention to create legal relations in continuation to our lectures on the formation of a contract, legal requirements for a contract. One of that legal requirement is the intention to create legal relations. For a contract to be enforceable, parties must have the intention to be bound by the terms and conditions of their agreement. They have to have the intention. The intention is not usually expressed in the contract, but then from the conduct of the parties or from the nature of the transaction, it could be inferred whether there is the intention to create this legal relationship. So we'll look at domestic agreements, commercial agreements, and some intermediate situations. Now, domestic agreements, for instance, agreements between spouses, relatives, close relationships, generally there is a rebuttable presumption not to be bound by agreements. What we mean is that the general assumption is that domestic agreements are not intended to be legally enforceable. Domestic agreements. So contracts relating to social aspects of say marriage will not be enforced. Why? Because the general presumption is that they are domestic agreements, domestic and social agreements, as against business agreements. How between spouses? If there are business agreements, then notwithstanding the fact that they are spouses, relations, or close relations, the law will be deemed that this agreement can be what? Enforced. Business agreement between spouses will be what? Enforced. There is this case of Balfour against Balfour. There is case of Jones versus Pudavatan. Then there is a case of Spellman against Spellman. Now let us look at commercial agreements. The assumption under commercial agreements is that they are presumed to be what? To be legally enforceable. The presumption, to rebut this presumption, the other party have to bring in evidence to rebut the presumption. But generally, commercial agreements are what? Enforceable. Rebuttable presumptions of intention to create legal relationships. We have it must be expressly it must be expressly in the contract. Things like mere bof, letter of intent, free gifts. These are all rebuttable presumptions in a contract. Now, burden of proof on the party alleging otherwise will be required. The burden on proof will be on the party that is alleging otherwise. The case of Khalil again, the case of Rose and Frank Company versus Compton Brothers Limited, instances of such presumption. So generally, for domestic or social agreement, the presumption is that it is not intended to be legally enforceable. But for commercial agreements, the presumption is that they are intended to be legally enforceable. It is left to the party who wants to rebut this presumption to bring evidence to rebut this presumption. So generally, these two categories of situations should be contrasted: domestic stroke social agreements versus commercial agreements. All of them are having different positions under the law of contract. Thank you.